So define the goalposts for me. I mean, you're saying they've gone past some goalposts, but Congress has not said anywhere, you, Commission, can't look at non-retroactive changes in law. It hasn't said you can't look at changes in mandatory minimum. It hasn't said, the only thing you can't look at alone, it said, is rehabilitation. That's the only limitation Congress has said.
Well, it has said, Your Honor, under 994A that the Commission's policy statements have to be consistent with law. As for rehabilitation...
Well, there is no law that says that. There's no law that limits what they can consider.
Well, Your Honor, I think even... I'm sorry.
And 3553A, thank you, I'm tongue-tied on that one, does permit courts to look at disparity with co-defendants or with others. So I don't know where you're defining that the goalpost is defined by something that's not specified in law.
Oh, so let me tease that out a little bit. I think they're not trying just to look at there are a few points. Number one is the colloquy I was having with Justice Kavanaugh in the first case about why the 3553A factors aren't the relevant consideration at this part of the inquiry. But even beyond that, they're not just looking at disparities alone. They're looking at disparities with offenders who were sentenced under a non-retroactive law that applied to them but didn't apply to these offenders. And I think even even my friends on the other side, would have to agree that you can draw some implicit lessons from Congress's enactments. To get to Justice Gorsuch's questions, that's exactly why the Commission would claim that it has exempted its own non-retroactive amendments from its policy statement. It's because it believes that if it didn't do that, it would be overriding the limitations in 3582C2. And if it can't override 3582C2, I don't understand why it can override Section 403B of the First Step Act. Essentially what they're saying is that because none of these statutes expressly speak to sentence reductions, I guess 3582C2 does to some degree, but it doesn't expressly preclude the use of 3582C1A1 when there are other circumstances involved, because they don't expressly speak to sentence reductions, they are automatically possibly on the table. And if that's true, then there's substantial separation of powers concerns, because then they essentially have the pen on sentencing law. Now, if I could address rehabilitation for a second, Justice Sotomayor, I think there are a couple of points. One is rehabilitation is something that I think could otherwise have been considered an extraordinary and compelling reason. I think there are examples of many prisoners who would claim that they have extraordinary and compelling stories of rehabilitation. One thing that they're able to do under their position is just to take that rehabilitation, combine it with a non-retroactive change in law, something we know Congress didn't want to apply to these kinds of offenders.
So do you think that someone who has rehabilitated, been in jail for 40 years, let's say, and is now 90 years old, and they have spent most of their life in prison, could not have a claim for compassionate release if they come in and said, I'm 90 years old, I'm going to die soon, because rarely do you last very long after 90. The chances are very slim. And now there's been a change in law. I can't qualify under your reading of this.
So, Your Honor, in the absence of B6, even the Commission wouldn't allow release under those circumstances, because it's not age as such. It's limited, I think it's B2 is limited to age-related.
So your answer is that wouldn't be enough?
I think it might be within the...
And there, I didn't add that there was a change in law, all right? Because that's what's at issue here.
So, Your Honor, though I think that those may not be extraordinary and compelling on their own. If they were extraordinary and compelling on their own, we wouldn't have, this question wouldn't ever come up. The other problem with 994T, I think, that's a real problem for them, is they don't if they want to follow the expressio unius principle from the consideration of you can't consider just rehabilitation alone to its logical conclusion, then I don't see how they're able to maintain their position. What 994T says about rehabilitation is that it's a consideration that can be considered in conjunction with other factors, but not on its own. But that seems to be exactly how they're treating non-retroactive changes in law as well. So if they think 994T is something that says only rehabilitation can be treated in a particular way, they're violating their own principle. I think 994T is just about limiting consideration of that one principle. If they instead think that non-retroactive changes in law can on their own be reasons why someone could get a sentence reduction, then I think there are even further problems with their position. But under their position, the Sentencing Commission could, in theory, come out with a rule that allows district courts simply to disagree with mandatory minimums. And then, as we specify in our brief, the district court says at sentencing, well, you don't qualify for the safety valve. Unfortunately, even though I'd rather not, I'm forced to sentence you to this mandatory minimum, but I'd be very open to a compassionate release motion. The prisoner files one the next day. He waits 30 days, and the district court, because the BOP is not going to endorse it, and then 30 days later, the district court's able to reduce the sentence. That cannot be the way this works. Yet if they say that that can't happen, that that's somehow some kind of abuse of discretion, that the commission doesn't have that authority, then I don't see how they have the authority they're asserting here.